The Government Law College Thiruvananthapuram was established in the year 1875 by the Maharaja of Travancore. It has carved its legal legacies in a span of more than 140 years and continues to function as a niche of promising talents.
We have produced numerous brilliant illuminaries in the political, judicial, and in the mainstream entertainment industries. In an extensively competitive world, it is an ineluctable fact that one needs to keep up with pacing skills to last out there. Mooting is one of such mastery for all the law aspirants seeking admission in this field.
Boundless history of 147 years slumbers in the land of Thiruvananthapuram Law College, which calls out the glorious stories and events of the college. We've succeeded in recognizing mooting as a talent long before and nourished the eloquence in our graduates through the Moot Society that have been inspiring us for several decades.
Talking about Moot Court is an innovative part of our curriculum. It imparts advocacy skills on the first hand and, of course, exposure to the procedures of a trial.
From my experience at law school, what I'd really like to expound is the fact that ours is a professional degree, like that of a medical practitioner or a mechanical engineer. The conclusion of our academics is in our capability in addressing the practical issues.
Every student who is there in the law school should attend at least 3 to 4 moot court competitions in his life in the campus. So that will give us a confidence to stand before a forum when you're out of the school, and that will empower you not only as a lawyer but also as a person in the future.
We proudly present 16th National Moot Court Competition to be held virtually from 10th March to 12th March. The race for Justice V.R. Krishnaiyer ever-rolling trophy to be held in the magnificent capital of God's country.
As a law student, it's very important that we improve our advocacy, and the Moot Court competitions helps us to gain this.
In an institution like Government Law College Thiruvananthapuram, we have the Moot Court Society, which forms the crux of all clubs. We have strict training policies, thereby polishing students to become the future lawyers.
If you want to go fast, go alone.
If you want to go far, go together.
Together, let's make this event a success.
The Government Law College Thiruvananthapuram was established in the year 1875 by the Maharaja of Travancore. It has carved its legal legacies in a span of more than 140 years and continues to function as a niche of promising talents.
We have produced numerous brilliant illuminaries in the political, judicial, and in the mainstream entertainment industries. In an extensively competitive world, it is an ineluctable fact that one needs to keep up with pacing skills to last out there. Mooting is one of its mastery for all the law aspirants seeking admission in this field.
The Government Law College Thiruvananthapuram was established in the year 1875 by the Maharaja of Travancore. It has carved its legal legacies in a span of more than 140 years and continues to function as a niche of promising talents.
We have produced numerous brilliant illuminaries in the political, judicial, and in the mainstream entertainment industries. In an extensively competitive world, it is an ineluctable fact that one needs to keep up with pacing skills to last out there. Mooting is one of such mastery for all the law aspirants seeking admission in this field.
Boundless history of 147 years slumbers in the land.
The Government Law College Thiruvananthapuram was established in the year 1875 by the Maharaja of Travancore. It has carved its legal legacies in a span of more than 140 years and continues to function as a niche of promising talents.
We have produced numerous brilliant illuminaries in the political, judicial, and in the mainstream entertainment industries. In an extensively competitive world, it is an ineluctable fact that one needs to keep up with pacing skills to last out there. Mooting is one of such mastery for all the law aspirants seeking admission in this field.
Boundless history of 147 years slumbers in the land of Thiruvananthapuram Law College, which calls out the glorious stories and events of the college. We've succeeded in recognizing mooting as a talent long before and nourished the eloquence in our graduates through the Moot Society that have been inspiring us for several decades.
Talking about Moot Court is an innovative part of our curriculum. It imparts advocacy skills on the first hand and, of course, exposure to the procedures of a trial.
From my experience at law school, what I'd really like to expound is the fact that ours is a professional degree, like that of a medical practitioner or a mechanical engineer, the conclusion of our academics is in our capability in addressing the practical issues.
Every student who is there in the law school should attend at least 3 to 4 moot court competitions in his life in the campus. So that will give us a confidence to stand before a forum when you're out of the school, and that will empower you not only as a lawyer but also as a person in the future.
We proudly
The Government Law College Thiruvananthapuram was established in the year 1875 by the Maharaja of Travancore. It has carved its legal legacies in a span of more than 140 years and continues to function as a niche of promising talents.
We have produced numerous brilliant illuminaries in the political, judicial, and in the mainstream entertainment industries. In an extensively competitive world, it is an ineluctable fact that one needs to keep up with pacing skills to last out there. Mooting is one of such mastery for all the law aspirants seeking admission in this field.
Boundless history of 147 years slumbers in the land of Thiruvananthapuram.
Good afternoon. Can you hear us?
What officer?
Good afternoon, sir. We can hear you.
Thank you.
Welcome, sir.
Yes.
Participants may please turn on the camera.
You made the S2, S1 and S2. And P1, P2 and PR. P1 and but P1 researcher area.
Okay, researcher.
We'll start.
Is there a briefing?
Is it required?
It's required.
We can start otherwise if you are all ready. Both sides are ready. All the best.
Yes, sir. We are having, every team is having 15 minutes for attending. Okay. And for rebuttals, we are having 5 minutes also.
Okay.
Let's start.
Good afternoon, Your Lordships. The Council seeks permission to individually address the panel as Your Lordship and collectively as the bench.
You can address as honor or sir.
Okay, sir. Thank you. The Council will be representing the petitioners in the case of Durga NGO and others versus the Union of Indus. The Council for the petitioners humbly reserves the right to approach the jurisdiction of the court as under Article 32 of the Constitution. If Your Honor is well versed with the facts, the Council seeks permission to proceed with the arguments.
Yes.
Much obliged, Your Honor. The first issue is with regards to whether the present writ petitions are maintainable. The Council for Petitioners submits before this Honorable Court that the present writ petitions, which have been filed by Durga NGO, Mrs. Sharda Devi, Ms. Fatima, Mr. Hemant, and the legal representative of Vairamani, are maintainable on 3 counts. Firstly, due to there being a presumption of constitutionality which is extended to personal laws and the questioning of which can be deliberated upon only under Article 32. Secondly, since the petitioners have the locus standi to file the writ petitions regarding the issues at hand in the Supreme Court of Indus. And thirdly, since the issues are ones which deal with substantial questions of law, by fulfilling this, the petitions stand maintainable. With respect to presumption of constitutionality, the present writ petitions are maintainable as personal laws come within the ambit of Part 3 of the Constitution. This was enumerated in the case of Shaira Banu versus Union of Indus.
Maintainability is questioned on what ground?
Much obliged, Your Honor. The petitioners seek to prove that the maintainability of these writ petitions are maintainable with our arguments.
That's what said. We are asking on what ground it was objected by the respondent. Why it is not maintainable?
Much obliged, Your Honor. I believe the respondents would contend that the writ petitions are non-maintainable as there have been no fundamental right violations, which is what we're seeking to prove with our issue.
If that is the case, why should you want to take us to the presumption of constitutionality?
Much obliged, Your Honor. We just want to elaborate upon how the personal laws do come within the ambit of Part 3 of the Constitution with respect to elaborating on presumption of constitutionality, if that is an argument that the respondent would contend on.
Yes.
Much obliged, Your Honor. The ratio residendi, which about whether personal laws are unconstitutional and violative of fundamental rights, was covered in Shaira Banu, as well as the cases of C. Masilamani Mudaliyar and John Vallamotam versus Union of Indus. Furthermore, the Apex Court in the case of M.L. Kamra versus New Indus Assurance has stated that while there exists a presumption of constitutionality with regards to statutory provisions, the same can be interpreted by the court when the provisions are prima facie unconstitutional, which they are in this particular case. Furthermore, a 3-judge bench in the case of NDMC versus State of Punjab stated that the courts must not put an unnatural or forced meaning to the language used by the legislature to save the statutory provisions. Essentially, the petitioners in this present case can question the provisions on the grounds of unconstitutionality, and the courts are supposed to consider the arguments without putting an unnatural or forced meaning to the legislative provisions to retain the presumption of constitutionality of the same. Moving on to how there is locus standi for the petitioners in this particular case. In the case of Mrs. Sharda Devi, the matter surrounds the constitutional validity of Section 15 of the Hind Succession Act. The constitutional validity of this section has already been brought to question in 2 High Court judgments. One, Mamta Dinesh Vakil versus Bansi S. Vadva, and the other, Saroja Chandrasekhar versus Union of Indus. Both these decisions are contradictory to each other, and they have been referred to a division bench. Since there is no specification with respect to division benches, the constitutionality of this section can be taken up by the Supreme Court. Therefore, the writ petition of Mrs. Sharda Devi, which seeks to resolve the constitutional validity of this section, should be considered alongside the division bench judgment for these cases. Ms. Fatima's petition with respect to the constitutionality behind the provision dealing with succession of property under Muslim law, where the daughter can inherit only 1/2 of the property inherited by her brothers, has also been addressed by the courts in the cases of Quran Sunnat Society versus Union of Indus and Sahara Kalyan Samiti and another versus Union of Indus, where high courts have referred this matter to the Apex Court, stating that Article 226 did not have the jurisdiction to decide the constitutionality of the same. Therefore, Ms. Fatima's petition serves the dual purpose of bringing forth this referral to the Supreme Court and the personal vested interest dealing with violation of fundamental rights. As per the case of Gurvayu Devaswam Managing Committee versus C.K. Ranjan, the High Court is disallowed from entertaining a writ petition by way of public interest litigation, which questions the constitutionality or validity of a statute or a statutory rule. Therefore, the writ petition by way of public interest litigation filed by Durga NGO.
What you understood by maintainability, yeah, that are still perplexed with your arguments. What is the maintainability actually? What is the maintainability you're referring now? Maintainability has to be either it refers to the locus standi of the person or with some bar in approaching the court.
Much obliged.
Ultimately, scope of interference with the personal law or a statutory law is a different. It's a matter to be considered on merit. Yes.
Much obliged, Your Honor. The petitioner dealt with presumption already. The council is presently dealing with how there is locus standi for each individual petitioner, since there's 5 different petitions being presented before this court, which have been clubbed together.
Regarding that, there may not be much dispute. Regarding the locus standi of the parties, there will not be much. But what my brother was asking was on what ground the maintainability is challenged by the other side. It is disputed by the other side.
Much obliged.
That a personal law cannot be challenged as unconstitutional. Is it so?
Much obliged, Your Honor, but we weren't presented with the arguments that the respondents is going to be presenting in this issue. So we believe that they would be bringing forth the presumption of constitution.
Okay, we understand you.
Much obliged, Your Honor. Moving on to the case of with respect to the writ petition which has been filed by the mother of Vairamani, in the case of SP Gupta versus Union of Indus, a public interest litigation can be filed by any member of the public to invoke the writ jurisdiction of the Supreme Court under Article 32, seeking redressal against violation of legal or constitutional rights of persons who are disadvantaged from approaching the court. In the case of Indus Banks Association versus Miss Devakala Consultancy Services, the court held that the petitioner who has moved to the court for their private interest and personal grievance, it can be treated in furtherance of public interest in the interest of justice. The court essentially held that a private interest case can also be treated as a public interest case. Despite Vairamani's mother not being a member of the transgender community, and despite her having a personal interest with regards to devolution of property of a transgender person, this is being a matter of personal grievance for the mother of Vairamani. By taking the above case laws in consideration, the writ petition by way of public interest litigation in this case should also be held maintainable. Furthermore, in the case of Sir Chunilal Mehta versus Century Spinning Manufacturing Co. Limited and Haryana State Industrial Corporation versus Cork Manufacturing Co. Limited, it was enumerated that the test for...
See, you're still simply straight away relying upon the precedents and since maintainable. You just tell us on the facts how the principles of law evolved and how you put forwarding your arguments. It's maintainable.
Much obliged.
We are aware of the precedents, but we want to know how you understood the principles evolving from it and how you want to apply on the facts of the case.
Much obliged, Your Honor. In the case, with regards to Mrs. Sharda Devi, if they went to approach the High Court again with regards to constitutional validity of Section 15, there is already a contradictory rule, and this has already been referred to a division bench. So therefore, the petition for Mrs. Sharda Devi should be held valid since they have approached the Supreme Court, since already there have been 2 petitions presented to the High Court providing contradictory decisions. Furthermore, with regards to Mrs. Fatima's petition, already 2 cases have been dealt with the High Court, where the High Court held with respect to the succession rights of Muslim women that the constitutional validity of this can only be taken up by the High Court, by the Supreme Court. Therefore, her petition should be held valid. Then in the case of the public interest litigation filed by Durga NGO, this should be held valid because writ petitions by way of public interest litigations are disallowed from being entertained by the High Court in the case of Gurvayur Devaswam. Therefore, their writ petition should be held valid. Again, in SP Gupta, despite not being a member of the transgender community, Vairamani's mother could file a writ petition, writ petition by way of public interest litigation on behalf of the transgender community. This is how it applies to each and every petitioner, Your Honor. Furthermore, all of these petitions have a substantial question of law with regards to the and a matter of general public importance. Therefore, they should be held maintainable. My second issue elaborates upon how upon how the provisions of the Hind Succession Act are discriminatory and constitutionally untenable. Can I proceed with the same?
Yes.
Much obliged, Your Honor. It is humbly submitted before this honorable court that the provisions of the Hind Succession Act are constitutionally untenable and fails the constitutional scheme of Indus, as it seeks to arbitrarily designate legal heirs based on classes. Firstly, as there is a presumption of constitutionality which can be questioned if it fails constitutional provisions. Secondly, as there is a violation of right to equality. And thirdly, as there is a violation of right against discrimination. Your Honor, with respect to the Article 14, there needs to be a reasonable classification, and there is a prohibition of class legislation. The test for reasonable classification includes needs to satisfy intelligible differential and rational relation as laid down in E.P. Roypa and State of West Bengal versus Anwar Ali Sarkar. Moreover, in Sri Ramakrishna Dalmia versus Sri Justice R. Tendulkar, it was laid down that when there is
You tell us what is how you challenge this.
Much obliged, Your Honor.
What is the differentiation you are trying to make out? Yes.
Much obliged, Your Honor. There are two major reasons that the reasonable classification is not fair in this case, Your Honor. In one, the objective of Section 15 is that the property must devolve upon the source where it has been inherited from, which was laid down in Bhagat Ram versus Teja Singh. And in this particular, essentially, if the property is inherited from the father, it would devolve upon the father's heirs. But in this scenario, since it is self-inherited property, it would immediately devolve upon the husband and children, but not the source. If you look into it, in detail, the professional education was funded for, and the woman developed only because of the contribution of her mother towards the same. Therefore, it becomes important that it devolves to the source, which in this particular case would be the mother, which would be Sharda Devi, since she has contributed to her professional education, which has resulted in her acquiring the property. Moreover, there is also a discrimination on the grounds of sex, since the rules for devolution of property for a Hindu female and a Hindu male are distinct and different from each other. Whereas in the case of a Hindu male,
indirect proximity with ultimate object, whether it would fall in the classification or outside the classification, the source should be very proximate, is it not? That's what law says.
Much obliged, Your Honor. The source should be proximate, but in this case, it is devolving upon the husband, despite the husband deserting the wife and living cohabiting with another woman. And the source in this case is clearly the mother, because she has paid for the education of her child, and
that's very having a subjective element. The law cannot be on very subjective element, because in particular case it may be, but not necessarily in every case. That's why the difference, because the self-acquired property and ancestral property. So it perhaps in your case might have been funded by your mother or so, but law looking at it as a class. So in that, our particular context, of course, could not be conceptualized by the legislature. So how can you say that that will not stand to the test of classification?
Much obliged, Your Honor, but there has been nothing laid down with regards to self-inherited property. It only goes based on the classes. Yes, it is in this particular case quite relevant, but even if we look into the sections in general, in comparison to Section 8, there is a clear discrimination on the grounds of sex. Why is it that the Hindu female, her property should devolve upon the marital family, but that is not the case with regards to the son? The Hindu male, his property devolves upon his mother first. The natal family gets the benefit, which is not the case with respect to the women. Why is there this clear distinction? That is also there is also no reasonable basis for such a distinction. This was actually mentioned in the case of This was actually mentioned in the case of Mamta Dinesh Vakil versus Bansi S. Vadva, where it was held that the women would not be able to, they would not be able to devolve the property upon themselves if ever, considering the provisions are laid out in such a way where the husbands can claim the property to the exclusion of the natal family. In fact, the natal family is not even considered in class 2 heirs, Your Honor. They're considered in class 3 heirs, which is not the case with the Hindu males. Hindu males, the natal family is considered immediately in class 1 heirs as well as class 2 heirs. Moving, Your Honor, if I may...
That exactly is the reason why there are different classes. That classification itself you have to challenge. We can understand if there is a distinction between women and females. But you are saying that it should be on the basis of the self-acquired property and otherwise. Your argument is that by mother should also be inherited. There are all reasonable basis for such a classification. How can I attack it on the ground of unconstitutionality?
Much obliged, Your Honor. If we go by the point about how it's unreasonable on the basis of, if I may be...
You can complete.
You can.
You complete that.
Much obliged, Your Honor. If we look into it, as you've mentioned, against females who have acquired property from their father, it devolves upon their father's heirs. That is, it returns back to its source. But for self-inherited property, if we look into it, we need to determine the source. That is it does not satisfy the objective of the act if it's devolved upon the husband and he does not serve as a source. The self-inherited property, we have to look into the contribution of the parents towards the person's professional education, which has resulted in her acquiring the self-inherited property. So there's a clear distinction. While in one case, women who have inherited ancestral property are able to devolve it upon their father's heirs, that is the source where they've received it from. But in the other, self-inherited property, they're not able to devolve it upon the source, the person who has contributed for the same. It is not, it is unreasonable, Your Honor.
Yes.
Which provision you are saying discretionary?
Discriminatory.
Whether 15 or 18? 8.
Section 15, Your Honor. Section 8 is also discriminatory. Those were my arguments, but since I have arguments for those as well, but since my time is up, if I can sum up the arguments as to how Section 8 is also discriminatory.
Yes, you can.
Mr. Hemant's petition.
Yes, you can. Sum up. We'll take 2 more minutes. You can take 2 more minutes. Yes.
Much obliged, Your Honor. Your Honor, in the Law Commission in its 204th report dealt with 5 major issues. One was the inclusive of an amendment. One included the amendment to Section 8, which is read along with Section 10, recommending that fathers must be relocated from Class 2 heirs to Class 1 heirs. This is to ensure that it satisfies the objective of the Senior Citizens Maintenance, Protection and Welfare Act. And moreover, the Law Commission report mentioned that fathers are much closer in relationship than those under Class 1 heirs, since Class 1 heirs includes grandsons, widow of grandson, great grandsons, several people who are not as proximate in relationship when in comparison to father. This proximity aspect is also covered under the Mitakshara school, which was elaborated upon in the case law of Arunachala Gounder versus Ponnaswamy. The Mitakshara school is a school which governs the laws of laws of succession for Hindus. Furthermore, the father has had complete custody of the son and has looked after the welfare of the son to become a balanced and productive member of the society in this particular case. In fact, in Gaurav Nagpal versus Sumedha Nagpal, it was mentioned that children do not amount to mere chattels or toys for their parents. And in today's altered societal reality, parents' absolute control over their children's fates and lives must give to considerations of their welfare as human beings, so that they grow up in a normal, balanced manner to become productive members of society. This contribution to the welfare and to become a productive member of society was completely and only done by Mr. Hemant, since he's had permanent custody of late Mr. Arun. The mother has not contributed to the same. And in Mamta Dinesh Vakil versus Bansi S. Vadva, it was mentioned that it was a matter of positive discrimination to put the mother in a class higher than the father. But the situation since 1956 has had a change, and it is important that that rule be amended. That was also mentioned by the court in this this case, Your Honor. So therefore, we can see that very clearly with relevance to Mr. Hemant's petition, where the mother is able to maintain herself since she has married into a new family and has 2 other children to look after her. Whereas that is not the same with the case of Mr. Hemant, who had nobody but Mr. Arun to be with, and he has.
Yes.
And one last point, Your Honor, I will conclude after that. If we allow the mother to devolve the property upon herself, Mr. Late Arun's property upon herself, it would go against the concept of which was laid down in Gaurav Nagpal versus Sumedha Nagpal. We would be accounting late Mr. Arun to be a mere chattel because she is acquiring the benefit. She is acquiring she's reaping the benefits of the hard work that Mr. Hemant has put towards the development of his child. Therefore, the counsel for the petitioners would like to conclude and would like to invite their co-counsel to elaborate on the remaining 2 issues. Much obliged, Your Honor.
Good afternoon. This is the co-counsel for the petitioners. If the counsel may please confirm, if the courtroom master may please confirm the counsel is both visible and audible.
Yes.
Thank you very much, sir. The council seeks permission to proceed with issue 3 with regards to whether the Muslim Personal Law Shariat Application Act, hereinafter referred to as the Muslim Personal Law, is constitutionally untenable insofar as it seeks to bestow daughters with only half of the property that is inherited by the sons.
Yes.
Much obliged, sir. It is humbly submitted that the Muslim Personal Law is constitutionally untenable on 2 major counts. Firstly, it is violative of Articles 14 and 15 of the Indus Constitution. Secondly, it fails the test of reasonable classification. It is important to note the origin of the Muslim Personal Law in this present case. The Muslim Personal Law arose from the protests of Muslim women organizations for better laws for women than the then customs and uncodified personal laws. The patent discrimination on the grounds of gender that daughters should only receive half of the properties inherited by the sons is arbitrary and violative of their fundamental rights.
Where does it say in the law that she would inherit only half?
Your Lordship,
is there any statutory reference we are referring?
It is one of the inherent submissions under the intestacy succession of Section 2 of the Muslim Personal Law Shariat Application Act.
Is there any law which says that women only inherit half?
Yes, sir, in Hanafi law, which is the primary law for Sunnis.
It is not a statutory law.
It is not codified per se, sir, but it is it is accepted and it is in practice.
Where in Sharia Act is refers for that?
Sir, it comes under Section 2 of the Sharia Act, which deals with intestacy.
What does it say about inheritance?
Sir, Section 2 of the Sharia Act largely deals with intestacy. However, this is one of the additional provisions that is clubbed together with Section 2. This is not codified per se, but however, this is the law that is in practice.
Then how can it qualify? It's called a law for the purpose of testing constitutionality.
Because, Your Lordship, in the various cases and in with regards to the writ petitions that have been petitioned before the Honorable High Courts, in cases of Quran Sunnah Society and Sahara Kalyan Samiti, it has been accepted by the High Court that this is in fact a very arbitrary law, and that is why they've referred it to the Supreme Court in the present case.
And what is the Narasimha's ratio?
Sir, the Naraswapa ratio initially, it was held in the Naraswapa-Mali ratio that personal laws do not count as laws in force under Article 13. However, this has been overturned by the landmark judgment of Indian Young Lawyers Association versus State of Kerala in 2018.
Is it overruled?
Yes, yes, sir. If the Honorable Bench would prefer, my researcher will send you the paragraph of the Indian Young Lawyers Association, which deals with the same. Furthermore, the Council will cover further arguments.
The personal law at a par, it kept at bay because it's part of religious liberty. Then, if you say that it has to be tested on the anvil of Article 14, then state would encroaching upon the personal liberty that is granted by the Constitution.
No.
Profess and practice a religion that can be only regulated in terms of very minimal area of Article 25 on the ground of morality, public health, or public.
So the Council very well agrees that the right to propagate one's religion is their fundamental right. However, it has been held in separate cases such as Ramatullah.
Then you have to accept that all the pujaris, priests are to be gender neutral. Would you agree with that?
No, sir, we beg to differ on this respect. In the case of Rahmatullah versus Katunisa, it has been strongly held by the Supreme Court that though personal laws are meant for the practice of that community, if they are discriminatory of the constitutional provisions, then it is the constitutional provisions that have to prevail.
Constitutional test would come only it's a law.
Yes, sir, but this has been considered as a law in the various cases, especially by the Honorable High Courts in two separate cases.
What qualifies the law? What are the imperatives of the law? How do you define a law?
Your Lordship, with regards to a personal law in the situation, if it has been in custom.
A law. How do you define a law?
Your Lordship, one that has been in practice and one that governs the society. Customs also come under laws.
You can easily call it as a law, but how do you discern as a law or
not? Sir, the council humbly states that given that this is a custom which has been in practice over the years and governs the right to inherit property of Muslim daughters and governs how they would inherit property in an interstate succession, it should be considered as a law. And one that governs a particular community with regards to their general livelihood and
yes.
13 is clear.
Yes.
And how will you bring it in the ambit of Article 13?
Much obliged, sir.
Is the custom also qualified as a law?
Yes, so customs also come under personal laws. However, customs, if this can be seen in the case of, however, personal laws can be overruled if they are against constitutional provisions, as also witnessed in the case of Mary Roy versus State of Kerala. The council may proceed.
Yes, you can proceed.
Thank you, sir. So, with regards to various cases such as Masala Mani Mudaliya versus Idol of Sheikh.
You are on a tricky issue. You are on a slightly tricky issue. Anyway, you go ahead.
Thank you, sir. So, in the case of Masala Mani Mudaliar versus Idol of Sri Swaminatha Thirukoil and Vinita Sharma versus Rakesh Sharma, it has long been held by various courts, including this very Supreme Court, that personal laws are derived not from the Constitution but from religious scriptures. However, if they are not consistent with regards to the Constitution, then they will become void under Article 13 of the Constitution.
What is the Constitution? What is the Constitution? What is the foundation of the Constitution?
The basic structure doctrine.
That's the nature of it. The Constitution imports an idea of rationalist natural principles, which is, I mean, in the sense it's different from divine thoughts.
Yes, sir. Yes, sir.
Divine thoughts have no foundation in the Constitution. They begin a secular document. So it is an rationalist ideals that is reflected in the Constitution. Same rationalist ideals also say that religious beliefs, ethos, practice can be protected because that is insulated. The very idea of rational thoughts given rise to the Constitution, that itself recognizes. You keep religious thoughts away. You can't test those within ideals of rational ideas. If you Article 14 what postulate? It postulates idea of fairness and arbitrariness in a secular or rational appeals, right?
Yes, sir. Yes, sir.
If you try to understand the divine thoughts in a rationalist manner, there would be an inherent conflict within it.
Yes, sir. The council admits that divine thoughts and there is a conflict in the present case as well. However, it has been repeatedly stated in various judgments by the Supreme Court that if a personal law violates the fundamental rights of the people,
that's what I'm saying. Fundamental rights are what? It's a rational thought, the reflection of rational thoughts.
Yes, sir. But in this present case, this provision that daughters only inherit half of the property given to their brothers is not rational, and it fails the test of reasonable classification in various instances. It fails both the tenet of intelligible differentia as well as rational relation. Because this very situation was also addressed in the case of Mary Roy versus State of Kerala, wherein the Travancore Christian Succession Act only gave daughters 1/4 of the total property given to the sons.
That's correct, because of statutory law. Once a law made for a particular denomination, then it becomes a secular law. Whether it be Hindu, Muslim, and Christian, that becomes a secular law. Then it has to stand the test of the constitutionality.
Yes, Your Lordship, but it is the council understands that. But however, this is not so, and only this isolated case.
In Mary Roy's case, that issue was not considered by the Supreme Court. Supreme Court only considered the question whether Travancore Cochin Act will continue after 1947. That was the only issue that was considered, and court held Indian Succession Act will apply. That's the difference. It did not say that the concept of ladies getting, women getting a lesser right is unconstitutional. It was not held.
But you much obliged, sir. But the daughters were also should the court also held that daughters should get equal rights as the
It's a passing comment. That was only a passing comment. The court did not go into that issue. Yes. Anyway, you go ahead.
Much obliged. Thank you, sir. Further on, moving as to how this present in this present situation, there is a failure of the test of reasonable classification, as was stated by my co-counsel. In the case of State of West Bengal versus Anwar Ali Saka, the twin elements of intelligible differentia and rational relation have to be fulfilled, which is not done so in the present case. In the present case, this Muslim personal law fails to fulfill these tenets. With regards to the 2005 amendment to the Hind Succession Act, which was reiterated in the case of Vinita Sharma, Hind daughters have the right to equal share in ancestral property. Furthermore, in the Inter Succession Act, there is no difference drawn between sons or daughters, but the act only refers to lineal descendants, and gender is not a differentiating factor. Therefore, why is this that only the Muslim daughters have to suffer through this discrimination, besides just maybe the preservation of archaic constructs? Further, moving on to the failure of the tenet of rational relation, in the case of P. Vijayalakshmi versus...
If your argument is accepted, without backing of any statute like a uniform civil code, the court will now have to assume the role of the guardian, maker of the law, and hold that Muslim women are also equally entitled for it. What the kind of law that would be? Is court-made law or a personal law been expanded?
Law to be enacted by
Yeah, of course, we can understand if a uniform civil code is made by the parliament, and
so the council admits that the
uniform court is competent to decide what should be the share in a property.
Yes, sir, which has been
witnessed. Muslim law, apart from the share of the women, there are many other manner it has been interpreted. On what manner the share has to be devolved, and it is for the court to decide what should be the share of women or any other
other father, mother.
There are a lot of shares have been referred. How the court to fix the share then? Because it will have an impact on the shares of others.
Yes, sir. The council understands that, and we. But however,
whether it's possible for the court to decide all these matters, what should be the share?
Sir, we understand that the court cannot legislate and cannot step into the ambit of the power of the legislature. However, the court is well within its rights to declare that a particular section of the act.
You are only referring to with the counterparts of male alone. You are referring the shares of the women. What about other shares? Their right would be impacted if court consequently declaring that women is also for equal shares.
So we understand that, but how is it fair that so long they have been gaining the shares of the women, and then now when women claim their final rights and they're unhappy with the shares that they've been gaining as an excess over the years?
You can also say the predeceased son is also not included. Predeceased children are also not, so they should be included. Can you say?
Sir, inherently this act, when there is gender discrimination, it is always the duty to redress gender discrimination and to make sure that such discrimination never takes place, irrespective of what section of
gender discrimination becomes superfluous argument then, because when there are different pattern of share have been prescribed in the personal law, your only argument based on the gender discrimination is superfluous because it would have an impact on the other shares.
But we understand that, sir. But however, when it is inherently gender discrimination, we understand that yes, there might be an influence of this on the other person's shares.
You could have come with a prayer for for implementation of uniform civil code or something like.
We understand that though a uniform civil code would be ideal and would be the ideal need for any lawyer or anyone from of the legal background, we understand that our nation is still a developing nation with a huge background in with the religious laws of the various communities. And we've also witnessed in various cases that in various cases such as John Valamottan and Sarla Mutkal, it was held that marriage and succession should be of a secular nature. However, given that we are still embroiled in a lot of religious background for our personal laws, we also have to take that in consideration at this point. The legislature, we understand that the legislature is working towards it in their own time, but however, given our situation as still a developing nation, and such a rich religious history with such...
Is your prayer not conflict with the basic tenets of the Constitution? Constitution proclaims secularism is the basic. Bombay case, it is held by Supreme Court, secularism. So now you're encroaching upon the religious freedom and deciding how a religion should govern themselves. Is it not against the very ideals of secularist principles?
The council begs to differ in the present case as well, Your Lordship, sir. But when a personal law is against the tenets of with regards to fundamental rights enforced to citizens, and such is witnessed in the Supreme Court overturning various judgments such as the triple talaq or even sati for that example, which have been in religious practice over the years as personal laws, but given that they're gender discriminatory and this would impact the right, like social and economic rights of a large member of the society, the court has very well...
If you go to that extent, when you come to the case of the other Hint Succession Act, you are treading into a more complicated issues, because in the case of Vaishnavi, you say that mother is entitled for a share. In the case of Sharada Devi, you claim that mother is also entitled for. Leave apart the personal laws. That's the problem. See, are we expected to decide what should be the share, who all are the persons entitled to get share, how it should be moderated? These are all based on certain sociological reasons or probably a reasonable classification. Unless you are able to point out what exactly is the reasonable, what is the unreasonability in the classification, how can you get a relief?
Yes, sir, but the unreasonability in the present case is gender discrimination. Further, as stated, in the case of C. Mani Vudaliar versus Idol of Sri Swaminatha Swami Tirukoil, personal laws, even though they derive from religious scriptures, if they are not in consistency with the Constitution, then they will be considered as void under Article 13 if they violate fundamental rights, and that is what the council is saying.
Yes. Yes.
Have you completed all your points, or you want some more time?
If the council may move on to issue 4 with regards to the non-exclusion.
Be brief.
Yes.
Yes, yes, sir. Surely. Yes, yes, sir. So with regards to the 4th issue, that is the non-inclusion of transgender persons within the ambit of the Hind Succession Act, which is the primary governing body for succession of Hind people of society, it is considered that this action of not including transgender persons is highly arbitrary on 2 major counts. Firstly, it fails to acknowledge people outside the binary gender block, which violates the right to equality, that is to be accorded to all citizens. And secondly, it forces people to conform to this.
Is there any exclusion of transgender from the ambit of succession?
Your Lordship, to clarify, transgender persons who do not fall between the binary gender block, who do not identify as either gender or fluid between the genders, are excluded in the Hind Succession Act, as is in the present case with the late Mr. Vairamani. Late Vairamani, they do not qualify and do not identify as either male or female, but as a Tritiya Prakriti or for the sake of argument, a 3rd gender.
Yes.
Thank you, sir.
How far it is inclusion of third gender would benefit them, in the sense, the binary identification is not done, of course. But are they not be either considered as a male or daughter?
Predominant character.
But this is highly discriminatory, as was laid out in the case of Nalsa. The Nalsa judgment clearly laid out that forcing people to conform to this binary construct of gender is highly discriminatory, as it violates their personal autonomy and breaches their right to privacy. And this has been substantiated in various cases over the years. So, yes, sir?
Actually, your point is that they should be known as a transgender rather than in reference to male or male. That's your concern.
Sir,
Not on a.
Sir, if I may, the council may clarify. Sir, there are, if for the sake of this argument and to be specific, the Hind Succession Act caters to essentially two genders, male, female, those male and female people who are medically identified at birth, as well as people who self-identify themselves. However, in the present case, in late Vairamani's case, late Vairamani does not identify as either male, female, be it physiologically or psychologically. He's both as well as neither. And this is the self-identification that Nalsa has clearly said that should be upheld, and anything done in the contrary would be violative.
Property inheritance, they may not have difficulty in inheriting the property, but want to be known as a transgender and
third class,
third gender. Or
Sir,
right to be known. See, right to be identified as a transgender may be a constitutional right now after the Nalsa judgment.
Yes, sir, but however...
You can say that they should not be either called as a male or a female. They should be known by a biological identity of transgender.
Yes, sir. The Nalsa judgment has clearly laid out one of the key cruxes of the Nalsa judgment is that self-identification is primary and should not be overruled. However, the Nalsa judgment has also laid down that legislation should include such people who do not conform to either gender and to prefer to be another gender within their ambit. And the fact that this person, the Hind Succession Act fails to do so is violative. That yes. And also the action of the civil court in dismissing the suit just because the Hind Succession Act does not reach out, does not include these people who do not conform to the binary gender block is discriminative, and that is what the council is stating as well with regard to the precedents laid down by this very Supreme Court.
Now you can conclude. Is it over?
Yes, so that is the brief summarization of all the arguments that the council had for the fourth issue. If the council has permission to present the prayer.
Yes.
Thank you for allowing this repetition. Yes, we understood.
Yeah.
Thank you. Thank you, Honorable Friend.
Do you know what are your prayers?
Yes.
All right, sir.
S1 or S2? Who is to start? S1 or S2?
Yes, sir.
Good afternoon, Honorable Bench. I'm S1 and I will start first.
Yes.
Yes.
Much obliged, Your Lordship. May it please this Honorable Court, this is Counsel S1 along with my sister Counsel S2 appearing on behalf of the respondents in the case concerning Durga and others versus Union of Indus. If Your Lordships are well versed with the facts of the case, may the Council move on to the contentions?
Yes.
Much obliged, Your Lordship. Your Lordship, the Council with the respondent has mainly three contentions to submit before this Honorable Court. Firstly, the provision of Hind Succession Act are not in violation of the principles of equality enshrined in Article 14 and 15 of the Constitution of Indus. Secondly, the Muslim law of succession conform with the principles of equality and hence does not violate Article 14 and 15 of the Constitution of Indus. Finally, the intestate succession of property of a transgender professing Hindu religion ought not to be governed under the Hindu Succession Act 1956. Of these, the first contention shall be dealt by this council, and the latter merits of the case shall be dealt by my co-counsel in detail. With the Lordship's kind permission, may the council move on to the contentions?
Yes.
Much obliged, Your Lordship. Your Lordship, the first contention is that the provision of the Hind Succession Act are not in violation of the principles of equality enshrined in Article 14 and 15 of the Constitution of Indus. It is humbly submitted before this Honorable Court that the provision under Section 8 and 15 of the Hindu Succession Act does not violate any fundamental right under the Constitution of Indus. The respondents contend that the personal law does not come under the purview of Article 13 of the Constitution of Indus. Classification need to be based on absolute scientific criteria, and hence classification is sound, Your Lordship. Existence as to the presumption of constitutionality of a statute. The denial of property to the husband under the Hindu Succession Act is not unreasonable. The denial of the son's property to his mother is unreasonable. The petitioners should be governed under the Hindu Succession Act 1956. It is humbly submitted before the Honorable Court that the provision of Hindu Succession Act are not in violation of the article of the principle. In the instant case, that is the instant case, Your Lordship. In the instant case, Article 8 and 15, Section 8 and 15 of the Hindu Succession Act does not violate the 14 of the Constitution, since both the provisions are not arbitrary. In this case, the constitutional validity of the source-based succession under 15 Clause 2 of the Hindu Succession Act was challenged before the court. In further, the institutional integrity of the family and maintain continuous succession to the property in favor of the family. To this effect, the heirs of the husband were permitted to succeed to women's property as a result of merging of a woman with her husband's family upon marriage. Therefore, it is an intelligible differentia and rational nexus.
What is a merger? How you say that? See, the marriage in once upon a time, a kind of a social impact and social union, and the family is considered as a unit in the society. Now, in a very changing world, there is joint family has disappeared. See, these all laws are made when in sociological behavior we accepted joint family. There is a social cohesion based on the family.
Indeed,
now the concept of the marriage have changed, where individuals that matters. They assert their rights.
Indeed, Lordship.
So that is the reason even Supreme Court also consider the irretrievable breakdown of the marriages, though it is not as a ground for a divorce, is being recognized because individual has right, individual expression. All the laws have been made in tune with that particular time. That's why it's cruelty or socially accepted title, some immoral behavior alone being considered as a ground. Now time has changed. When time has changed, laws are not changed.
Indeed,
so maybe at the time when laws were enacted, it is constitutional. But by passage of time, social cohesions have undergone changes. Social ethos have changed. When individual become a matter, an individual autonomy become a matter for that. In such situation, how can a law stand its constitutionality in tune with a changing scenario of the time?
Should we not take into consideration those aspects also while interpreting the provision?
Indeed, Lordship, the concept of the respondents clearly understand the set matter. It is truly relevant. It is completely relevant, Your Lordship. But here we want to bring in something which is different from what we have contended before. That is, when it comes to a differentiation, if that is on rational nexus or intelligible difference.
Your argument is that wife has merged with the family of the husband.
Indeed, Lordship.
That was there in once upon a time. Now not exist in those kind of relationship.
Indeed, Lordship. We clearly understand that, Lordship, but this particular devolvement, let me just be very specific, Lordship, this particular devolvement is only with respect to her self-acquired property, and everything else, that is her something which is granted to her by ancestors, is still being transferred in the same devolvement, Your Lordship. This is only with respect to her self-acquired property, and
that's exactly the problem, because entire money was spent by her mother and made her to a self-reliant. She earned the money. You deserted, the husband deserted and lived with another paramour or something like.
How he claims
so the law becomes so cruel. It's not arbitrary.
Your Lordship, we believe that there is an existence of presumption of constitutionality in this particular statute.
Absolutely correct. You are right.
Presumption is always.
Presumption of constitutionality will remain there unless until it is impeached through the process of challenge.
Indeed, Lordship.
That's why they are here before us challenging it.
Indeed, Lordship.
So their essence, the case is their law is not, in essence, is not in tune with the changing time.
Indeed, Lordship. Lordship, we clearly understand the set constraints, and we do all the concept of response also put forward is that here the difference or the rational nexus is just not on the basis.
You're disconnected or some problem with your network.
I think the speaker one
is having some issue with her network.
Let's wait for some time.
Okay.
Yes.
I'm so sorry, Your Lordship. I'm facing a bit of technical issues. I'm so sorry for that. Am I clearly visible and audible now?
Yes, you are visible and audible. You can continue.
I'm so sorry for the technical glitch, Your Lordship. Moving forward with the said argument, all we're contending is that as the petitioners and the learned counsel for the petitioners clearly mentioned that there is a they invoke
Reasonable, you are arguing on that.
Indeed, Your Lordship. Your Lordship, what the petitioner said here is that they said there is a discrimination on the basis of Article 15 and 14. Whereas what we are contending here is that there is no such discrimination on the basis of 15, because here we are not considering gender alone, Your Lordship. We are considering many allied factors with respect to gender. There are many other factors such as family ties, social stigmas, etc. Thus, the only factor that we are considering here is not gender, Your Lordship. Thus, there are scientific scientific classification, and in the specific case, it is not necessary that there need to exist an absolute scientific classification. If the purpose of the classification can be linked with the purpose of the enactment, then the term scientific can be applied, Your Lordship. Your Lordship, Article 15 secures the citizen from every sort of discrimination. But even though, let me just, if with the permission of the Honorable Lordship, may I quote a case here?
Yes.
Much obliged, Your Lordship. Your Lordship, in Air India versus Nargis Misda, the Supreme Court stated that what Article 15 Clause 1 and 16 Clause 2 prohibit is that discrimination should not be made only and only on the basis of sex or gender. These articles of the Constitution do not prohibit the state from making discrimination on the ground of the sex coupled with other consideration, Your Lordship.
Yes.
Here, what we are contending is that the only discrimination, as my learned counsel for the petitioner said, that we are discriminating on the basis of gender. No, Your Lordship, the discrimination is not only on the basis of gender, Your Lordship. There are many other allied factors for this particular law or this particular thing to be enacted, Your Lordship. In the instant case, let me just take...
Just one thing. What is the object sought to be achieved by this classification?
In Your Lordship, the object, every act has an object and reacted to it. So in this particular act, the object is succession, Your Lordship. And even if there is a difference, as I said, Your Lordship, even if there is this particular thing is dealt, there is nothing which is ruining the succession, or there is nothing which is affecting the succession as such, Your Lordship. And thus, this particular classification stands still, Your Lordship. Moving on, in the instant case, Your Lordship, the classification is not made on the basis of sex alone, but also on the basis of family ties. Therefore, there is no violation of Article 15 of the Constitution, as quoted by my learned counsel for the petitioners, Your Lordship. Your Lordship, thus, it is humbly submitted before this Honorable Court that here there is no violation of Article 15, Your Lordship. With the kind permission, may the council move on to her second sub-issue, Your Lordship?
Yes.
Much obliged, Your Lordship.
Yes.
Much obliged, Your Lordship. Your Lordship, it is humbly submitted before the Honorable Court that there exists in that a presumption of constitutionality of a statute, Your Lordship. The presumption is always in favor of the constitutionality of enactment, and the burden is upon who he attacks it to show that there has been a clear transgression of constitutional principles, Your Lordship. The assumption is that legislature understands and corrects and appreciates the need of its own people, and it's the law are directed to problem may manifest by experience and are based on adequate grounds, Your Lordship. Therefore, it is contended that the Hindu Succession Act 1956, passed by the legislature is one such act that have been made under understanding and appreciating the custom and traditions followed by those professing Hindu religion, Your Lordship. Your Lordship, moving on to the next sub-issue, it is humbly submitted before this Honorable Court that the denial of property to the husband under the Hindu Succession Act is not unreasonable, Your Lordship. As per the Section 15 Clause 1 of the Hindu Succession Act, when a female dies without preparing a will, then the devolvement of a property is done by the said class, Your Lordship. And even if she is living apart from her husband without a proper divorce, the husband remains the husband's, Your Lordship. The mother remains the mother, the husband remains the husband. If there was a legal divorce or something of that sort which breaks the tie, Your Lordship, then we could clearly state that that person will be eliminated from the class, Your Lordship. But until then, until the husband remains legally wedded to his wife, the whole thing remains the same, Your Lordship.
Yes.
In the instant case, Dr. Rajiv, who is legal husband to Dr. Rukmani, is entitled to her property, Your Lordship. Since the husband comes under class 1 here, and since Dr. Rajiv, who is the husband of Dr. Rukmani, is a legal successor of her property, hence the denial of her property of the husband is clearly unreasonable, Your Lordship.
Yes.
And taking it from the side of the respondents, Your Lordship, who knows? Tomorrow they might come together, Your Lordship. So this particular possibility exists, Your Lordship. And mere living apart from each other does not amount to a clear denial of his property to her, Your Lordship. Your Lordship, moving with the permission of the Honorable Lordship, may the Council move on to her third sub-contention, Your Lordship.
Yes.
Much obliged, Your Lordship. Your Lordship, moving on to the next sub-contention, it is humbly submitted before this Honorable Court that the denial of son's property to his mother is unreasonable. According to the Section 8, let me just take the example of the current case, Your Lordship. In the instant case, Vaishnavi, who is the mother of Dr. Arun, is entitled to her property of a son by virtue of Section 8 of Hindu Succession Act. Even though Mrs. Vaishnavi is remarried, it does not bar her from succeeding the property of her own son, Your Lordship. The same principle is applied over here. That doesn't make her, that doesn't deny motherhood from her, Your Lordship.
No,
she's a mother and she will remain the mother.
Counsel, we are not deciding it on the basis of the possible eventualities. We cannot assume things that decide the question of legality. Yes.
Indeed, Lordship. Your Lordship, what the counsel will respondent wanted to quote is that the mother will remain the mother even though she gets remarried, Your Lordship.
Yes.
The motherhood cannot be snatched away from a woman just because she got remarried. The mother, remarriage and everything is associated with her own husband, Your Lordship. When it comes to her offspring, that is her son, mother remains a mother until her death, Your Lordship. This is a very strong principle, and this should not be damaged in any sort of arguments, Your Lordship. Yes. That is contended by the respondents, Your Lordship. Your Lordship, therefore, the denial of son's property to his mother.
Just wait, Counsel.
Just a second. Same contention, will it not apply to the other position? Because there also mother is denied when female dies. Mother remains mother. Should apply in case of, how will you reconcile both this contention?
Indeed, Lordship, here what the counsel or the respondent wants to quote is that particular law has already been enacted. Here we are stopping the law to be amended, Your Lordship. That is there, Your Lordship. We are not contending that to be anywhere wrong. All we are stating is that this particular thing to be right, Your Lordship.
Yes.
Yes.
Much obliged, Lordship. Your Lordship, therefore, the respondents humbly submit before the Honorable Court that the provisions of Hind Succession Act are not in violation of the principles of equality entrenched in Article 14 and 15 of the Constitution because it clearly tests all ambit for it to be valid, reasonable, and non-arbitrary option. That is all from my part, from contention 1. Further, the merits of the case will be dealt by my sister counsel. It was a pleasure arguing for you.
Just two.
Thank you. Am I audible, Your Lordship?
Yes, sir.
May it please this Honorable Court. This is Counsel S2 along with my co-counsel S1 appearing on behalf of the respondent before this Honorable Supreme Court. This counsel will be dealing with the final two contentions before this Honorable Court. Firstly, whether the intestate succession of property of a transgender professing Hindu religion ought to be governed under the Hindu Succession Act of 1956. And secondly, whether the Muslim law of succession conforms with the principle of equality and if it violates Article 14 and 15 of the Constitution of India. With the Lordship's kind permission, may the counsel move to her first contention?
Yes.
Much obliged, Your Lordship. The first contention is about transgender succession. Your Lordship, the Hindu Succession Act of 1956 clearly states the intestate division of property of both the males and females as per Section 8 and Section 15 plus 1 of the Act. The Act does not specify about the succession of Hindu transgender anywhere, hence the civil court could not have made a decision about a statute which was not yet in presence, Your Lordship. Therefore, the decision by the civil court was not lawful. Your Lordship, according to the Transgender Persons and Protection of Rights Act 2019, a transgender person shall have a right to be recognized as such in accordance with the provisions of the Act. That is, according to Section 4, Section 5, 6, and 7, it specifies on how a transgender is to be recognized. It states that a transgender person may make an application to the district magistrate for issuing a certificate of identity in such form and manner and accompanied with such documents as may be prescribed, and that the district magistrate then shall issue a certificate of identity as a transgender person after following the procedure indicating the gender of such person. Now, the transgender person shall be recorded in official documents in accordance with this certificate that has been issued, and it shall confer the rights and the proof of recognition of his identity as a transgender person. The person who has been issued a certificate of identity under Section 6 shall be entitled to change the first name and also their gender in the birth certificate and all other official documents relating to the identity of such a person, Your Lordship. In the present case, Vaidamani has not provided any such certificate as provided in the Transgender Persons Act 2019, as it has never been specified in the facts, Your Lordship. If the party had provided the necessary documents as per the statute, then his property would have been divided as per male succession under Section 8 of the Hindu Succession Act, Your Lordship. Hence, the decision of the lower court is correct, Your Lordship. My learned counsel from the opposite party, from petitioner themselves, has stated that Vaimari did not have a gender certificate, but which would further, where I would like to further state that transgender adoption by a transgender is still not legal in the country, Your Lordship. So there is a question on whether or how the succession would pass on to the adopted children of Vaidamani, because in the fact it has been given that Vaidamani has adopted a male and female child, Your Lordship.
So suppose such an application is not filed, what will be the consequence?
Your Lordship, the adoption would then be illegal.
No, the earlier application you said under the act you have to apply so that your name, gender will be enclosed and entered. Suppose such an application is not filed, submitted, what will be the consequence?
Your Lordship, then Vaidamani's property would have been divided according to the gender at his birth.
By virtue of which provision?
Your Lordship,
you said it would have gone as per the succession.
Indeed, Your
Does
Lordship.
it make any difference? Does it make any difference then?
Your Lordship, there is a difference between the succession of a male and female Hindu, Your Lordship. Your Lordship, the next sub-issue in this specific contention is that the court cannot invoke Article 142 of the Constitution of India, Your Lordship. The Supreme Court in the Union of India versus State of Maharashtra and others has stated that Article 142 cannot be used to include on legislative territory, which is one of the limitations while applying Article 142 to any case. The Supreme Court has also stated that the court cannot redefine, rewrite, or recast a statute because it lacks the authority to legislate. The court has not been given the authority to legislate, as it has also been decided in Pravasi Bhalai Sangatan versus Union of India. Your Lordship, the legislature, the executive, and the judiciary should operate within their constitutionally defined areas. No organ can take over the duties of another. The Constitution relies on each of these organs to function and use their discretion while scrupulously adhering to the procedures which is laid out in the Constitution. Each of these organs needs to be strong and independent for it to work properly as specified in Asif Hamid and others versus State of Jammu and Kashmir, Your Lordship. The Supreme Court has also observed in the Institute of Chartered Accountants of India versus Price Waterhouse and another that the judges should not imply that they are acting as legislatures only to show off their judicial power, and they must keep in mind that there is a narrow line that divides adjudication from policy making, which is a line that should not be breached. In Union of India versus Association for Democratic Reforms and another, the Supreme Court has further observed that it has no authority to amend the Act or the statutory provisions. The Act and the rules must be amended by the Parliament, and also no directive can be issued which violates the Act or the rules, Your Lordship. The present case,
we are conscious about that limitation, doubt about that. But the question is, will that preclude us from determining the constitutionality of a statute?
Your Lordship, as per from the part of the response, I would like to state that there is no unconstitutionality in the present Act, Your Lordship, because under the Hindu Succession Act, Section 24 and 25 talks about the disqualification for succession, and being a transgender is not one of those. This is because of the fault of the petitioners or because of Vairamani's fault, Your Lordship. If Vairamani had provided a gender certificate, his property would have devolved upon as per Hindu Succession Act, Your Lordship. Therefore, in the present case, the council seeks that this honorable court may not provoke Article 142 of the Constitution, as it would transgress into the boundaries of the legislature, Your Lordship. If Your Lordships are satisfied with this issue, may the council move on to the final issue. Much obliged, Your Lordship. The final issue of the respondent is that the Muslim law section does not violate Article 14 and 15 of the Constitution of India. Your Lordship, there is a rationale for double share of property to men. Under Muslim law, there exists no difference between the rights of men and women. Upon the death of any ancestor, there exists no impediment which could prevent either the girl or the boy to become legal heirs of inheritable property. However, it has still been noticed that when it comes to the amount of property or the quantum of share, the female usually receives half of that of the male heirs. The reasoning provided behind this is that under the Muslim law, a female shall upon marriage receive the meher and maintenance from her husband, whereas males will have only the property of ancestors for inheritance purposes, Your Lordship. Also, males have the duty of maintaining their wife and children, and thus must acquire more share than the females, Your Lordship, which has been provided under the Muslim succession, Your Lordship. There is no violation of Article 14 and 15 of Constitution of India under the Muslim Succession Act. Article 14 of the Constitution of India reads...
Is it a personal law? Is amenable to the challenge?
Indeed, not, Your Lordship, because Muslim personal law does not fall under Article 13 of the Constitution of India, Your Lordship.
How do you define a law then?
Your Lordship, under Article 13, Clause 2, a law...
what are the parameters to call it as a law?
Your Lordship, a law, according to Article 13, Clause 3 of the Constitution of India, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usages having in the territory of India the force of law. Laws in force includes laws passed or made by the legislature or other competent authority in the territory of India before the commencement of the Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas, Your Lordship.
Yes.
Your Lordship, if I may continue...
We follow Muhammadan law because of the Shariat Application Act, is it not?
Indeed, Your Lordship.
When such a statute is there to adopt Muhammadan law, though it is a customary law, can you say that it does not come within the purview of Article 13?
That is the reason the Supreme Court struck down Talaq, the two judges, I think Justice Nariman and other, struck down the two subclause something like related to Talaq and said that it is arbitrary.
Your Lordship, the Council would like to contend that triple talaq was a custom, whereas the succession...
What is struck down is a statutory provisions recognizing it. Not the custom has been struck down. Statutory provision recognizing it has been struck down by two of the judges of the 5 bench. One held that what is bad in theology is bad in law.
Yes. Indeed, Your Lordship. But in the if the Council may, the Apex Court has also held in a plethora of cases like Krishna Singh versus Mathura Ahir, Maharishi Avdesh versus Union of India, and Reynold Rajamani and another versus Union of India that personal laws do not come under the purview of Article 13 of the Constitution of India, Your Lordship. My learned counsel from the petitioners had stated that Narasu Appamali case has been overruled. However, Justice D.Y. Chandrachud has made a comment about it. The court has not yet explicitly overruled the particular case, Your Lordship.
That has not been overruled, yes.
Indeed, Your Lordship. Therefore, the Muslim law of succession cannot be challenged on the ground of violation of fundamental rights of the Constitution of Industrial Lordship. That was a final contention. If your lordships are satisfied, may the council move on to her prayer.
Not necessary. You are seeking a dismissal with a cost. Okay, rebuttal. You can go for other petition. Can go for rebuttal.
Much obliged.
Your Honor, before we proceed with the rebuttal, we wanted to know if the two councils can rebut, or is it just one council that is supposed to do the rebuttals?
I think as per the what is the rule?
What is the rule, court officer? Court officer, can you hear us?
Two councils can rebut.
They can share.
Both
They
the
can.
councils can rebut. Right.
What is
and,
it?
as per our rules, there are 5 minutes for the rebuttal.
Yes.
All together. Together.
Yes.
Yes.
Max.
Much obliged, Your Honor. Your Honor, beginning with the rebuttals, Your Honor, starting with the last issue that they dealt with, they brought up that certification is what certifies transgenders and their gender. The certification which is laid down in the Transgender Persons Act certifies them as a transgender and not any particular gender. The NALSA judgment, as well as the Transgender Persons Act, allows them self-identification of gender. Moreover, succession has already been for transgenders has already been dealt with with regards to a Muslim in the case law of Ilyas, where it was where the transgender person's property was allowed to devolve upon his heirs as per the religion and not as per the custom, that was that the transgender's property's heirs should devolve upon another transgender disciple. Furthermore, they in almost all their arguments, they have justified that these sections are applicable to the cases, but they have not spoken on how they are constitutional, which is what is the crux of the petitions which are presented before this court. They have just justified that as per with regards to the facts of this scenario and with regards to the sections, the property should devolve upon the husband or the property should devolve upon the mother. They haven't answered our questions with respect to how they are constitutionally valid. Furthermore, they went on mentioning that the disqualification sections don't make any mention of transgender persons. The disqualification sections deal with the heirs, Your Honor. They do not deal with the person whose property is to be devolved. In this particular case, it is dealing with Vairamani's property, who's a transgender person, and their property must devolve and the rights behind the same, not as heirs. Furthermore, they kept misgendering late Vairamani. Late Vairamani did not fall within the binary, so continuously mentioning them to be part of the binary was not accurate. Furthermore, they went on to I would like my co-counsel to present her argument.
Yes.
Thank you. Adding on to my learned co-counsel's rightly put rebuttals, in fact, with regards to their argument stating that the mother is always the mother in respect to their respondent's argument with regards to Mr. Hemant's petition, they say that the mother is always the mother and therefore her the property should be devolved to her. However, Your Lordship, as rightly put forth by my counsel in her arguments, children should never be treated as chattels. And it is clearly witnessed in this case that Mrs. Vaishnavi has remarried, has married to a house with a husband and 2 children who can very well provide for her. Whereas in this case, Mr. Hemant is still unmarried and is looking after the late Mr. Arun. Therefore, just stating that the mother is the mother for the sake of property is highly questionable, sir. And moving on to the fact that the Law Council for the respondents is stating that the late Vairamani, if he has an identification certificate as a transgender, then the court will take them into account as males under the Hind Succession Act, is highly disrespectful and against the ratio decidendi of the NALSA judgment, which clearly laid that people who do not fit into the binary should never be forced to fit into the binary, and the legislation should evolve above the binary, take into account those who do not fit into such spectrum. And moving on to the concept that with regards to their fourth issue, in stating that daughters are not liable to a share in the intestate ancestral property because their primary security is meher is completely archaic as a construct, because it's not proven that meher will definitely be given to a woman, every Muslim woman. In the present case, Ms. Fatima is unmarried, and furthermore, there have been several cases because meher is to be given by the husband's family and not the natal home. There have been several cases where the husband has never given meher up till his deathbed, and the heirs are now liable to pay the meher.
But who will take care of the marriage of others? The female will take responsibility, or the male would take responsibility? Because social reality is there. When there are, you keep aside this argument, when there are male issues and female,
yes, sir.
Suppose in as far as the sister's marriage is concerned, who will spend the money?
Sir,
Normally, the social reality.
So it's when the father is not
Who will
present,
have
it is the
who is
brother.
having the responsibility?
When the father, sir, when the father is not present,
Suppose
it's the brother.
there are two girl child, two girls.
Yes, sir.
And one boy, one brother.
Yes, sir.
And as far as the marriage of that one elder daughter is married, assuming that the last daughter is not married, who will take the responsibility sending the marriage? The elder sister will take, or the male brother will take?
Sir, as per convention,
Social reality. I'm asking social reality.
Sir, there's conventionality as well as modern times, sir.
No, social reality is a rational. I mean, basis of law. Many of the laws have been made. The moral ideals.
Yes.
Yes.
The council agrees.
Don't say that we are male chauvinist.
No, sir.
Don't say that we are male chauvinist, but that's the reality.
Yes, sir. The laws are structured so.
But
yes,
not
sir.
legally.
It's not the reality.
Of course, sir. It is largely dedicated to the patriarchal construct that the sons have to take into account that their sisters arrange their marriages if the father is not present. However, in the present case, Ms. Fatima is unmarried.
Law is designed in such manner. Is there any law casting a liability on the female or women to pay maintenance? All have been leaned against the male. They are the responsibility.
Yes, sir, because of the historic discrimination against women, sir. That is the reasoning behind it.
There's now reverse discrimination.
No, sir, not at all.
Your Honor, if I may add, also,
Just one thing. You go to Domestic Violence Act. All the reliefs are in favor of the wife.
And Maintenance Act also, in everywhere you find that responsibility comes from the male. So is it not a discriminatory?
No, even though
Your Honor, if I may add,
provided she has completed, P2 has completed.
You can add, not as a part of it, but still we want to know from you.
Much obliged, Your Honor. In response to your queries to my learned co-counsel, Article 15.3 has provided for discrimination towards women, has provided for positive discrimination towards women, which is why all the acts that have come about till now have been favoring them, because of the social reality back then that women were not equitable to men. But right now there is a changing social reality, and right now we find that the groom and the bride are paying for their own weddings. It's not the parents that are taking the obligation.
So we need to change the law as well now.
Yes, Your Honor.
With evolving times.
The code to meet the evolving times.
Evolving time. You are right.
Yes, S1 and S2.
Yes, S1 and S2. Once to make some comments on it, you can make an add on it.
Indeed, Your Lordship. We would like to rebut what our learned counsel for the petitioners clearly said. To make it more clear, I'll just rebut it one by one, so there is no confusion. So first of all, as my learned counsel for the petition said that we ourselves named Vairamani as male, you should have referred to the clarifications, learned counsel for the petitioner. It is clearly stated in the clarification given by the organizing institute that she identified herself as male. Thus, we have not ourselves assumed that person to be male. Then, second, I feel that this is my time. May I continue, Lordships?
Yes.
Indeed, Lordship. Also, the next contention that was put forward by the learned counsel for the petition was that we did not address constitutionality. That was the first thing that we addressed, Your Lordship. The twin test, that is the first thing that we addressed. We clearly said that there is an intelligible differential. We clearly said that there is a rational nexus. There's said discrimination. We clearly meant that there was no discrimination on the basis of one single thing, which was contended as gender. We clearly said that was not the case here. Thus, we have already addressed the constitutionality of the case pertaining in hand, Your Lordship. Then, moving on to the next thing, that meher. Meher is something which we believe as it is a custom of Muslim law. And we believe that customs are genuinely followed by the people. And as my learned co-counsel for the petitioner said, that some people don't get meher.
Unmarried daughter.
Unmarried daughter, Your Lordship. Indeed, Lordship, we clearly understand that, but we believe that meher is a custom and that is truly followed. When it comes to unmarried daughters, if we take examples like that, then this is just respect to the self-acquired property, Your Lordship. We can move to several facets of this particular succession, Your Lordship. Thus, just merely taking out meher and saying that this particular thing is not invalid, that really not constitute or that really not invalidate the contention made by the respondents, Your Lordship. That was a brief of what the rebuttals that we had. We have further more points, but we believe that we don't have that much of time in hand.
Next time we can have.
That will be beyond the rebuttal. You will be explaining, arguing once again.
Indeed, Lordship, we don't want to take much
I
time.
said here all, we reserve our verdict. Okay, thank you.
Thank you, Lordship. Have a good day, Lordship.
Thank you.
Thank you so much, Your Honor.
Validity വേറെയാണോ?
Court officer, we are coming back after some time. Will it be on a separate platform?
We'll come at 4 o'clock sharp.
Okay, so thank you for attending the session, for every participants and the honorable judges of the High Court on behalf of the institution. Thank you, sir.
We'll come back at 4.
Thank you so much, Your Honor. It was a pleasure pleading before you. Thank you so much.
Seconded,
It's a
sir.
pleasure pleading for your honorable court.
മോശം ടി വിന്ന് എതിരെ സെലക്ട് ചെയ്തോളാം. 2 മോശം ടി വിന്ന് എതിരെ സെലക്ട് ചെയ്തല്ലേ?